Hello everyone, welcome to This Family Does Everything. My name is Alexandria and this is the next part of Judge Dorow and Darrell Brooks. So let's sit back, watch and analyze the Darrell Brooks trial.
I believe the two FBI agents were with me in the room, and then, like I say, Mr. Brooks was escorted in by Detective Stern.
Did you introduce yourselves? Well, you had been with Mr. Brooks previously, correct?
Objection.
Yes, I had.
Overruled, he may answer.
Yes, I had.
Okay. Had he been introduced to Detective Stern already?
Yes, he had.
Okay. And how about the two FBI agents?
It was at that point that they introduced themselves to Mr. Brooks.
What was his reaction to that when they introduced themselves?
Objection. Relevancy.
Overruled, he may answer.
I'm very surprised. He said the word FBI, in the form of a question. I could tell his tone was very surprised. It wasn't as calm as he had been. He seemed concerned, uneasy, and within about a minute after stating that, he questioned the agents further as to whether they were really FBI agents, and he was surprised to see them there, and he had never actually seen an FBI agent before, so he was definitely surprised, and I could tell he was uncomfortable.
Did you record the entire conversation you had with the defendant?
Yes, at that point, all that is on recording. At that point, yes.
And have you had the opportunity to review that recording prior to today's date?
I have.
I would like to admit Exhibit 81 for the court. It is the audio interview of the defendant that took place on November 21st, 2021. It's previously been addressed by this court.
Objection.
Remind me how long it is again.
Your Honor, the entire video is 25 minutes approximately. I'm asking to play from 4 minutes and 25 seconds to 14 minutes and 25 seconds approximately. Well, it would be 10 minutes.
I presume you'll have questions regarding that once you play it.
Correct.
All right. Given that it's just before 5 o'clock, I'm going to stop for the day. We can pick up with this tomorrow. You can sit down for the moment, and I will have our instruction for the jurors. Ladies and gentlemen of the jury, do not begin your deliberations and discussion of this case. Your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capability. Reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the evening. We'll see you tomorrow morning. All rise for the jurors, please. I'm printing out a draft of preliminary, you can be seated, in jury instruction 60, which concerns use of an interpreter for a witness. I have a question about that second paragraph, which relates to whether the witness knows some English or not, and so we'll review that tomorrow morning first thing, but it'll be provided to the parties, so you have that to look at this evening. With that, I'll see everyone tomorrow at 8:30. Thank you. Thank you. Be seated.
Okay, thank you. I gotta get back to them. Okay.
I need my staff and then. All right, good morning, everyone. I will get started. I will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good morning, Judge Sue Upper, Leslie Basie, and Zach Witchow appearing for the state of Wisconsin.
Good morning. Good morning, sir. Please state your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any other facts in the charging instruments.
Record should reflect that the individual known to this court as Darrell Brooks is present in person in custody in street clothing, wearing a suit and tie and a mask.
For the record,
today.
I do not consent to being called that name, Your Honor. My name is Darrell Brooks, Jr.
All right,
And we still have yet to address subject matter jurisdiction.
The court has
the
addressed
record.
it for the record. So we
For the
will
record,
be,
has it been proven?
Mr. Brooks, I stand by the written decision that I issued in this case last week. A second
what written
copy was
decision are you
provided. Please
referring
don't
to?
interrupt me. A second copy was provided to you. I know you saw it because you tore it up yesterday. So I'm not going to address it any further.
Are you
You are
talking about
mistaken and wrong about the law that it needs to be verified or proven.
Are you talking about the paper I accepted in return for value?
So with
Accepted
that,
for value in
I
return for
believe,
value?
Mr. Brooks, I'm going to continue with this trial, whether you believe jurisdiction has been proven or
It has not been proven for the record.
And it has. So
It has
with
not.
that, Detective Carpenter was on the stand,
And it needs to be proven
and I
per the prosecution.
would like to have him brought back up unless there's any other issues the parties wish the court to address from the state.
I did want to address something briefly.
Go ahead.
As the court knows from our short discussions yesterday, the state will be playing a couple videos of the defendants and his statements. The court had previously heard those as part of a motion hearing, and I'm not sure if I'm really giving the defendant notice or what I'm doing, but I really tried hard, and I'm pulling out snippets from this because if the court recalls, there are a lot of references that the defendant makes to prior domestics with Erica, his prior record, things that the court had previously excluded. So I'm going through and I am pulling specific time ranges from this so that nothing that was previously ruled inadmissible comes in. And I guess obviously this defendant has the absolute right to cross-examine the witness. He has the right, and we've offered and we have been putting exhibits up for him. But I do want it to be noted that I would not be willing to have Mr. Brooks just say, oh, go to about the 7-minute mark, because if he even goes like 2 seconds before a clip that I had played or 2 seconds after, it could include information that was previously ruled inadmissible. And I guess what I would say to the defendant is the court has previously protected the defendant to make sure that things didn't come out. Where he asked a question that could be construed as opening the door, and the court said, we're not going to go there, Mr. Brooks, and he got the message. However, with this, if there's any portion of this video that's played that talks about the prior with Erica, I do consider that he has opened the door, and I will be asking the witness about it. So I guess this is maybe more so directed at Mr. Brooks, that if he plays clips that contain that information, he will have opened the door. He's had this video for weeks at least. These videos have been subject to a motion hearing. I'm not sure exactly what access he had to them before. I've reviewed the 5-hour video a number of times. I've been very meticulous in my timestamps that I'm grabbing out from here. And I am unwilling to have the defendant put Ms. Gussie in a spot where he's kind of, well, around this point. He needs to give exact times that he wants started and stopped, because what happens is if he says, okay, can you pause here, by the time he says that, 5 seconds may have gone by, which may be enough to, some of these, if I would play 2 more seconds than what I have here, it would open the door. So I just want the defendant to realize that this is kind of a slippery slope here, and he proceeds at his own risk. And I'm not going to ask Ms. Gussie to stop it at a certain time because I think something's about to be said. That's on the defendant. And if he opens the door, I can assure you I will go into it. So I did want to put that on the record, Judge, not to be a jerk about it, but just once it's out there, I can't not address it. And if it's the defendant who brings it out there into the view of the jury, then I'm going to feel compelled to address it. And then I didn't know if the court wanted to go through the preliminary instruction that you had provided previously on the interpreter. My understanding is that Mr. Marquez speaks very little English.
All right, thank you. As to the first part, to what the state brings up regarding the redacted recording, I would remind Mr. Brooks the court did enter some rulings previously. Why do you have to roll your eyes at me? Let's start the morning off.
I didn't roll my eyes at you, so I don't think it's fair that you should say I rolled my eyes at you.
I saw you roll your eyes at me. I'm not
I
going to
didn't roll
debate
my
about
eyes
it.
at you, so don't do that.
Well, Mr. Brooks, I'd appreciate a little bit more respect. These
I would too,
rulings,
Your Honor.
let me finish, because now you're interrupting me. These rulings were entered by the court to prevent other acts evidence from coming in. But a defendant can open the door in a variety of ways. These recordings, and I have reviewed them previously, do contain discussion and statements by you regarding these other acts. And as you heard from Attorney Basie, she has all of the timestamps to stop at appropriate times so that the state does not run afoul of those pretrial rulings. You can open the door by asking questions, by asking for a video to be played, and not knowing those exact timestamps. I think it's important that I reinforce what the state has just advised you of, so that when you are watching the recording, as all of us will be, if there is something you want replayed and you want to cross-examine the witness about, that you know those time stamps, and then the state has graciously indicated they would assist once again in replaying portions of that video. I don't need a response from you unless you feel you would like to give a response to any of that.
With all due respect, they're the ones that want to play the video, so I don't understand how I'm the one opening the door. They chose to play the video, so
They're not going to play the entire video, though. They're going to redact out, probably stop, fast forward the portions that this court said would be inadmissible. So for example, if during your cross-examination of Detective Carpenter, you ask the state to replay a portion of the video and you say, go back to around the 7-minute mark, you have to understand that you may open the door, even inadvertently, to some of those other acts, evidence coming in. So what I'm telling you is, if you want any portions replayed, then, or if you ask for the entire video to be played under the rule of completeness, that you have an understanding that you would be opening the door to the evidence of other acts coming in. Potentially, I'll have to rule on it at that time. So be mindful of the timestamps.
I don't understand, and Your Honor, that's almost like you making a ruling and then it not having any standing. If you already made a
the
ruling,
ruling's against them. I told the state they can't offer this evidence.
right?
They're
That's
the
what
one.
I'm saying.
So if you offer the evidence or ask questions that would open the door, that's a different story. And we all have treaded lightly when you've asked questions that would have opened the door to a variety of witnesses. So the state's just simply saying, look, we're going to do our job. We're not going to put in the other act's evidence. We're going to pause the video, fast forward the appropriate spots. But if you want any portions replayed, or if you ask for the entire video to be played, then you do that at your peril of having those other acts' evidence come in. So that's all I want to tell you. As far as the jury instruction, do you have any position on whether that second, well, I shouldn't say second, it's the very last paragraph where it says, add the following if appropriate. Do you have any position on whether the court reads this entire jury instruction 60 to the jury prior to Mr. Marquez being called as a witness?
Yeah, I think the jury should hear whatever needs that they need to hear.
Do you have a position on that last paragraph specifically, sir, given the information that the state has provided today?
Last paragraph.
It's in brackets, and it's after a bolded section that says, add the following if appropriate. I advised the parties yesterday we would be talking about that this morning.
I mean, it was just stated that the witness doesn't speak very good English. And so that would indicate that it would be a lot more work for the interpreter to make sure.
That's not what I'm asking about, sir. I'm asking whether you have a position on whether I include the very last paragraph of that instruction to the jury.
No, I don't feel like that needs to be read to the jury. I think it's pretty clear from all the language leading up to that.
Let me ask Attorney Basie a question about the contact the Office of the District Attorney has had with Mr. Marquez. Were you able to communicate at all in any way in English, even if you would describe it as broken English?
Yes, I think our last conversation, we probably said, I said something in English, he responded, and then when I said something else, I think he needed translation for that. His primary, our victim witness person, specialist assigned to the case, is bilingual, and she speaks to him in Spanish.
All right, given that bit of information provided by the DAs and Office of the Court regarding his ability to answer some but not most, I think it's appropriate to read the very last paragraph. Certainly doesn't hurt. It's not going to take away. So I will read the entirety of jury instruction 60. Obviously the part that says read here if appropriate comes out, and then I will print that off, and that is what I will read at the appropriate time. Did that print, Madam Clerk?
Quick question on that. How do we know exactly what words the witness will be able to understand in English versus?
That's not how the interpretation works. The questions are in English. They're interpreted in Spanish to the witness. The witness will answer, presumably in Spanish, and then the witness's words will be interpreted in English. And it's the English, as this instruction says, that is the evidence.
I think it's a little unfair that prosecution has had conversations with the witness and I haven't, considering that it's my witness.
They were on the state's witness list as well, I believe. So it's fair for either party to reach out, and if witnesses want to talk to either party in preparation, that's frankly fair game.
So how would I be able to reach out to a witness?
Mr. Brooks, you are representing yourself. That obviously poses some challenges and difficulties, but that is the state and stage that we are at. So with that, I know we'll get Detective Carpenter on the stand. He can come up and be out here when the jury comes out. So come on up, sir. I will swear you in again, as is my practice when there's a witness on the stand for a second day.
I have one more thing real quick.
Well, it needs to be other than subject matter jurisdiction, so what is it?
You didn't even let me get to it.
I said, what is it? I said it needs to be something other than subject matter jurisdiction.
Can I
What
get
is
to it?
You can say.
There's no way to know what I'm going to say if I can't say it.
Mr. Brooks, please tell me what it is you'd like to address.
I want to address why my ICFs have not been addressed, because I know you have them. Why have I not getting copies? I've gotten copies of every other ICF. Why not the recent ones?
Sir, I am not going to be the intermediary anymore for ICFs that are directed to the clerk of court regarding copies.
That's not explaining why I haven't.
I'm not the
even been
keeper of
told
the record,
if
so
they've
if there's
been
something
received.
you want me to address, then you should address your ICF to me and not the clerk of court.
Well, where is the ICF? If
Sir,
I sent it, I
I
should be
am
able
not-
to get a copy. I've gotten copies of every single one.
You need
whether
to
they were
ask
addressed,
for that from the clerk of court.
whether they were addressed to you or whether they were addressed to the clerk of courts. I've always
I'm not going to
been
address
told.
that further, Mr. Brooks. I'm not going to be the intermediary when
So
you
what's
have
the-
questions to the clerk of court.
So
for
what's the
copies
point of
and
me
things like
sending the
that.
ICF, me doing what you asked me to do, and sending them, and then not being able to know if they've even been received and get a copy of them, which I've been getting
If
copies
you
of
did
them
not
ever
ask
since.
for a copy of the ICF, they don't have any obligation to
I
send it.
I addressed it when I first sent it. I asked you on the record, did you receive it?
Mr. Brooks,
You
I
said-
didn't receive anything because nothing has been sent to me.
Well,
So
where's the
if there's
ICF?
something that you need, then you should reach back out to the clerk of court.
I shouldn't have to do
But we're
that
not
if I
going to
sent
take
it.
up court time regarding an ICF sent to the clerk of court. Again, I will advise you once again, I did this the other day, if there's something case related, it needs to be addressed to me. If it has to do with the record, it needs to go to the clerk of court.
And it was.
Because I
It was
am
sent to the
not
clerk of court.
the
But I still should be.
custodian.
I still should be able to be told if it was received and get a copy, which you've done that before every single ICF.
And I told you I
So why
would
does
no
it change?
longer be doing that, sir, because of this very issue. It
So you
takes
saying
up
so
court
now it
time.
changes? So now it changes all of a sudden?
No, it didn't change all of a sudden, sir, and you know that. So don't
No,
try to
no.
confuse
Does
the
it
record.
change all of a suddenly? Because
No,
I've been
it-
getting copies of everything I've sent, which is what you asked me
This
to do.
changed last week, and you
It
know
should.
that.
It shouldn't change.
So
no, I
with
don't
that,
know it.
I'm bringing the jury out, and I'm not addressing this issue.
So
sir.
I
We're
want the
gonna
copy of
continue
my
forward.
ICS that I send.
Send the request to the
I don't
clerk's
have to
office.
send another request. Where's the one that I just sent last week?
All right, the jury is going to come out, so please be respectful.
I will, but at the same time, you still have to. I did what you asked me to do. If you tell me to do something and I do it, and then now you're saying I'm not going to get a copy, which you've been providing them ever since you told me to do it.
Mr. Brooks, the rules on that changed last week.
No,
You know
no, it
that.
did not. I'm still supposed to be able to say if it's been received or not. So why should I have to send multiple ICFs to even know if they've been received? That's ridiculous, Your
I'm
Honor.
going to give the parties the final version of jury instruction 60, which I will be reading at the
That's-
appropriate time.
Come on, you can't change stuff at the last minute. You
No,
asked me
Mr.
to
Brooks,
do
I
something.
did it as a courtesy,
You
and
act-
frankly,
no.
you're not courteous
I'm not.
to me.
I'm not
So
even.
the
I'm
jury's
not even.
coming out.
I'm not even
The
referring
record
to
should
that.
reflect that the jury
I'm referring
is
to the
coming
fact. I'm
out.
referring to the fact that you haven't even
Mr.
had enough
Brooks,
respect to tell
please
me
be
it's been
respectful
received.
to the jury. They're coming out.
Okay, that doesn't mean that you shouldn't be able to tell me if my ICF has been received. ICFs that you told me to submit. You told me that.
Ladies and gentlemen of the jury, you will disregard the commentary by Mr.
I
Brooks
accept for
at this
value in
point.
return for value this document. Just like you've been hiding everything from the jury that they
The
need to
jury
use.
will disregard. The court is not hiding anything from the
Yeah,
jury.
yeah, you are.
So,
Yeah, you
Mr.
are.
Brooks, please be respectful of the jury. They're
And
coming
you
out.
should be respectful
We
of
are,
what you asked
you are
me to
addressing
do.
issues that are not related to evidence
They
in
are.
this case.
You asked me to do
Mr.
something,
Brooks,
I do it,
please.
and
all
then
right.
now it changes.
Everyone can be seated. Thank you.
This is ridiculous. Just like subject matter jurisdiction hasn't been proved. Just like you're making judicial determinations that you don't have to prove
on.
anything by law,
Hold on.
which is a tacit agreement by you, Your Honor.
Ladies and gentlemen of the jury, please disregard the statements currently
Why? 'Cause
being
it's
made
true?
by Mr. Brooks.
Why?
They
'Cause
are
it's true?
Incorrect statements of the law. They
Then
are
prove
not
that they're
evidence
incorrect. Prove.
in this case.
Where's the proof? Where's the legal proof?
And you need to disregard them.
Because you don't have it.
And we are
Don't
going
have
to
legal
continue
proof.
with testimony, Mr. Brooks. I warn
I
you,
don't-
do
I don't-
not interrupt.
I don't
or
identify by
We will
that
have a
name.
discussion about whether you will continue to be here.
I don't
All right.
consent to being called that name for the record.
Detective Carpenter, please stand, as is my practice when a witness is on the stand for a second day to be sworn in again. Go ahead, Teresa. Please raise your right
Lie
hand.
to the jury.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. And just for the record, please state your name for day 2.
Detective Jay Carpenter, Jaycarpenter.
All right, thank you. Go ahead, you may continue.
Sir, yesterday when we ended for the day, we were at the point where we were talking about you interviewing the defendant, Darrell Brooks, on November 21st, 2021 at approximately 11 o'clock p.m. Do you recall that?
Objection. I don't consent to being called that name for the record. My name is Darrell Brooks, Jr.
Objection is overruled.
Yes, I do
Grounds
recall
for the
that.
overrule.
Not relevant.
Yeah, it is relevant.
Your Honor, at this point, or I think last night, we asked for State's Exhibit 81 to be admitted into evidence, which is the defendant's statement provided to Detective Carpenter and Detective Stern on November 21st of last year.
And Exhibit 81 is received permission to publish is granted.
Objection.
My notes reflect that it's 25 minutes.
That is correct. Let me get the exact time of it.
Objection. I didn't provide any statement on the 21st.
Jury will disregard the statement by Mr. Brooks. He is not testifying, therefore his statements are not evidence.
And my objection should be noted for the record.
Your Honor, the entire video is 25 minutes and 27 seconds. The state will be playing from 4 minutes and 25 seconds to 14 minutes and 25 seconds.
Thank you. Go ahead.
So before it begins, I just wanted to clarify, we had talked about it last night a little bit. What we are hearing today is the audio interview only, correct?
Objection leading.
Overruled is foundational. She may ask it that way. Go ahead. You may answer, sir.
Yes, that's correct.
Okay, thank you.
I'll tell you. Tight.
Hey, Darrell?
Yes, sir.
Hey, Darrell. I'm Jeremy Wojcicki, the FBI.
FBI.
Yeah.
FBI?
I'm Mary. Yep.
They're just kind of helping out because we're so short-staffed tonight. So
Thank you.
Yeah.
that's all it is.
How's your shoulder, right? Is that where
Yeah, well, he said in 4 to 6 weeks I might have to get it because it's still something's wrong.
I know.
You bang it up before or something?
Nah, it was just the way they slammed me.
Okay.
Hit the ground, kind of like went up. Boom, boom. That's where the knee came from. But, yeah, but the shoulder, I know something's wrong.
Yeah.
He said 4 to 6 weeks, the MRI won't be able to tell if anything's torn or anything like that. So.
Okay.
FBI though.
We help out our local partners all the time. This is just something that we're here to
Because I'm like, what?
Yeah, believe it or not, we work at MPD a lot. We come down here, so we're kind of all over the place. But yeah, like Detective Carpenter said, we're
y'all for real. The FBI for real.
That's what this says, at least. Yeah. Yep.
I'm not trying to be funny, but this is the first time I've ever even seen an FBI agent in real life.
We get that reaction from most of us.
No, because it's like, am I in a movie right now? Y'all sure y'all not punking or pranking me or something?
Yeah, you don't need to let that freak you out or anything.
Right.
Again, we do work, so we work on a task force with MPD quite a bit, so
I'm
we are out
gonna
with...
put my arm like this just to stretch it out. I don't want you to think I'm doing nothing crazy.
You good? You good?
It leaves some pressure. Something right up in,
No, you're good. Yeah, like she was saying, don't let them get out. Don't let them make you nervous. Okay. You'll be talking to me mostly and my partner a bit. No, they'll ask you a little too, but just trying to get to the bottom of everything. Look, you were found basically running around in the yard. You said you grabbed dude's phone. That's
I didn't grab it.
I
actually.
don't mean you stole it. You
asked
for it and you made a call. And And that's just kind of what I'm up here to start with and get the background about it. Darrell, is it Darrell? Do I have the spelling right?
Yes, sir.
And it's D. Edward, like full middle is Edward, right?
Yes, sir.
Brooks, Brooks.
Yes, sir.
Okay. And just verify your date of birth for me.
2/21/82.
82. So you're 39?
Yes, sir.
Okay. All right. Married at all?
No. I said, little as I am, I'm like, you had to slam me.
Yeah. How many kids you got?
3.
3? How old are they?
18, 14, and 7.
18, 14, and 7. Yeah. What do they like to do?
My baby girls, they into everything that's going on right now. The TikTok, the Instagram,
right?
They always dance and making videos. My oldest daughter just started high school.
Yeah.
And my baby girl she just started the 1st grade. So
Yeah. So they could all
my son is the oldest. My girls are the youngest.
they could like build a computer, but can't normally talk like we know how to, right? So you're born in Milwaukee?
Actually, Detroit.
Detroit.
Yes, sir.
Living in Milwaukee now?
Yes, sir. Grew up here. We left Detroit when I was I don't even think I was walking and talking yet. So
Okay.
Milwaukee's home, Wisconsin's home, born and raised.
Okay. Not working right now, right?
No, not at the moment. No.
What do you do when you're working? What do you like consider your job?
The last job I just had, I was working at a sheet metal place.
Okay.
Basically just they would have like these like hook things, like you just basically it's strenuous because you got to do a lot of lifting and it's a lot of heavy lifting, but you basically just hanging these pieces on these hooks and they're going through the thing, they're steaming them, painting them, then they come back around and then you just box them up and load them.
So you're not married?
No.
You have a girlfriend?
Yeah.
You live with her?
No.
What's her name, your girlfriend's name?
Her name is Erica Patterson.
How does she spell it?
Erika.
P-A...
Yeah, Pattersson.
Okay, and it's 4014 North 19th Street in Milwaukee. Do I have the right address?
Yes, sir.
Is that an apartment or a house?
It's a house.
Okay. What's the zip code there?
53209.
Okay. And last grade you completed in school?
12th
grade? Okay. Graduated high school?
Yes, sir.
What school did you go to in Milwaukee?
Riverside.
Riverside?
Yes, sir. Milwaukee Riverside Tigers. I see you smile. You know about Riverside, man?
I heard things.
We kicked y'all butt in football.
Nah, it was West Dallas.
Oh, no.
I don't think we play Riverside.
Yeah.
Okay. All right. So, yeah, I appreciate all the cooperation and all the good dialogue we've had, to this point, Darrell. Being that you're sitting here and I had some handcuffs on you before and all that jazz.
Absolutely.
You familiar with your legal rights?
Yes,
Have
I
you ever
have.
had those read to you before?
Yes, I have.
Okay. So as you can see, they're written on this paper. So because, if I was sitting here and talking to you on your couch, we wouldn't have to worry about this. But because you're here and not in your home, it's kind of a thing I got to read to you, okay? And again, it's just something I got to read to you before I kind of get your side or hopefully get your side here and love to hear your side. I'd like to know what Darrell has to say about, okay, we got some people calling us saying this, he said, you made hundreds before. No, I wasn't driving. Someone thought you might have been. He had to get that warrant. He ended up calling a guy just to use his phone, kind of loitering around and just, how you ended up kind of being it. That's what they say.
No. I was going to say, I knocked on his door to use his phone.
Yep. Right, but it probably wasn't him that called because he got his phone, but someone was concerned about something. So just trying to figure out what's going on down in that neighborhood. Does that make sense?
Yeah.
Okay. All right, Darrell.
You kind of, like I said, that wasn't probably the best, but I was just like, I need to get an Uber.
Yep.
I have money on my Cash App card.
Yep.
So I'm not trying to rob anybody.
Sure.
I'm not trying to break it and obviously you can tell I'm not drunk. I'm not, under the influence of anything. So.
Okay. All right.
So basically what it was.
Okay. All right. In regards to these, Darrell, then, do you understand that you have the right to remain silent? Just answer everything with a yes or no.
Yes, sir.
Okay. And then I just write down your reply. Understanding the above rights, Darrell, are you willing to speak with me, us, primarily me? I'm the one that's going to be doing most of the talking, probably.
I just want to know a little bit more about what's going on. Just a little bit, because
Like I
I'm
told
just
you, I know very
confused.
little. I just know that, you're down in this neighborhood, someone called, they didn't know what you were doing down there and things like that. So I got limited from their side, but I'm looking to see, what you have to say about it. I'm looking to see, maybe the caller was just on some BS down there. I don't know. I don't know. But I can't really show the court that if I don't have, if I haven't talked to you. So that's why I'm here, just to kind of see what you got to say about it. Get your side of it. Running around a neighborhood's not the end of the world. It's not a huge deal.
Right. Unfortunately, I wouldn't have had to do that if I made better decisions with women.
Yeah.
But not gonna point the finger.
Sure.
I'm a grown man. I make my own decisions, so I'm not gonna point the finger at nobody. I just didn't think.
Yeah.
What the hell?
You want to speak with me, Darrell?
Not right now.
So, was a decision made to speak with Mr. Brooks the following day?
Objection. Being called that name, leading the witness.
The objections are overruled. The witness may answer.
Yes, ma'am, it was.
Now, when you spoke with the defendant on the 21st, what did you have some general information as to casualties from the parade?
Yes, I did.
What information did you have at that point?
At that point, not all the information was in yet, but I knew, as I stated in previous testimony, our emergency department was very full. I knew there were significant injuries to many people. I knew some were deceased. I did not know the exact number at that time.
You had approximately another couple minutes of conversations with Mr. Brooks before you called it a night. What was the vibe that you got from him during those couple minutes?
Objection. I don't consent to being called that name. It's leading the witness.
The objection's overruled. You may answer.
I would say friendly. I think when you heard the clip there, Mr. Brooks jokes about Riverside and football. The individual he was talking to at that time was Detective Stern, as you can't obviously see him in the video. I could sense, and I believe you can hear it in Mr. Brooks's voice in that clip, the FBI put him on edge. It was unusual to see them. I could sense the nervousness. He did transition as I talked to him more throughout that clip into a more normal conversational tone again. But when I was speaking with Mr. Brooks casually throughout the night, that was the type of tone he had with us. It was very friendly, and he seemed, when it came to myself and Detective Stern, very comfortable speaking with us.
Now, you had stated your initial intent was to talk to him about loitering in the area that he was arrested. Do you recall that?
Objection. Speculative.
Overruled. The witness may answer.
Yes, I do.
Did Mr. Brooks at all talk to you about the loitering in terms of what the focus of your investigation was that night?
Objection. I don't consent to being called that name. Leading the witness.
Overruled. The witness may answer.
Yes, the statements he made in there, about, being in the area because he needed an Uber. He says more, to us about not knowing the area of Waukesha. He doesn't know the streets, things of that nature, and he just needed an Uber to get home. That was his reasoning for being down there, and he stuck to that reasoning the entire time.
What do you try to do when you're meeting with someone? Do you try to establish any type of rapport with that person? Is that helpful? How did you approach this interview on the 22nd?
Objection. Leading.
I'll sustain it to the form of the question. It was actually compound. If you could rephrase.
How did you approach the questioning of Mr. Brooks on the 22nd?
Objection, I don't consent to being called that name.
Overruled. The witness may answer.
So when I began to speak with Darrell Brooks on the 22nd, I began with some very light conversation. I explained to Mr. Brooks that I had more information from the previous day. I explained to Mr. Brooks that his girlfriend at that time, Erica Patterson, had made some domestic abuse allegations against him that were physical in nature. I didn't indicate to him exactly what she said he did, but that there were physical allegations.
Now, when we look at Exhibit 174, it says spouse's name, it says Erica Patterson. Do you see that?
Objection, leading.
Sustained it to the form of the question. You did not ask to publish. I did not. I just want to make sure that's what you were not looking to do.
Correct. No.
Okay. Thank you.
There's a spot in this form that says spouse's name. Is that filled in?
Yes.
And what does it say?
Objection, leading.
Overruled. The witness may answer.
It says Erica Patterson.
Did he say that they were married?
He did not. He said that was his girlfriend, however.
And he indicated he had children?
Objection, leading.
It's background foundational. It's the witness may answer. The objection's overruled.
Yes, he did.
How many children did he have?
Objection, leading.
Overruled.
3.
And you read each of the 5 rights that are listed on this form?
Yes, I did.
And did he agree to speak with you?
Yes, ma'am, he did.
Okay. I would ask that Exhibit 174 be published to the jury.
Objection, relevancy.
The exhibit's already been received. Noting your objection, it's overruled. Permission to publish is granted.
Now, as that form is coming up in the jury box, just for the jurors to see, when you initially had contact with the defendant that morning, did you verify if he had been fed?
Objection, speculative.
Overruled. The witness may answer.
Yes, I did.
And had he been fed dinner the night before, breakfast that morning, lunch that afternoon?
Objection, hearsay.
Overruled.
Yes, he had.
And was he complaining about any physical injuries?
Objection, hearsay.
Overruled.
Yes, he was continuing to complain about, excuse me, he was continuing to complain about the injury to his right shoulder, which he still at that time was asserting occurred when officers at the time of his arrest body slammed him.
Now, with regard to the second interview, the one that took place on November 22nd, was that recorded?
Yes, it was.
And would it be fair to say that recorded interview was 4 hours, 55 minutes, and 30 seconds?
Objection, hearsay.
Overruled.
Yes, that would be correct.
Okay. And you've had the opportunity to listen to that interview?
Yes, I have.
I'm going to go through that interview with you. I'm not going to play the whole 5 hours, but just portions of that. I'll stop it during specific clips that I'm providing to Ms. Gussie, and we'll talk about it. Is that all right?
Yes, that's fine.
Okay.
Before you do that, I'm told our interpreter will be here momentarily, and rather than you start, I think it would be best if we just take a short break till the interpreter's here.
Yes.
Is the witness here?
I believe he was coming at 10.
Oh,
We
okay,
thought we'd
that's
take
fine
a
then. Then I appreciate that additional information. Then we'll keep going. Sorry for the interruption.
Let me see if maybe he's here early.
Okay.
He's not here yet.
Okay, then we will keep going, and just let me know when the witness gets here.
Okay, you can take this exhibit off the screen. If we can go to 7 minutes and 30 seconds to 8 minutes and 20 seconds. Date. Now, before she starts it, is this the interview room that was at the San Mosquito Police Department?
Yes, it is.
Okay. And it's paused right now, but who's in that room?
Objection, leading.
Overruled.
The person in that room in the red t-shirt with the mask partially covering their face, longer braided appearing hair, is Darrell Edward Brooks. the same individual sitting to my left in this suit, jacket, shorter hair, and surgical mask.
Okay. And the other two people depicted here?
The person, as you would look to the screen to the left, is myself, and on the right is Detective Ben Stern.
At one point you had indicated, guys like you get into these kind of situations with girls like that, or something to that effect. Do you recall that interaction in this video?
Yes, I do.
What do you mean by that? Or what were you trying to establish by making that statement?
Again, as I had stated in my earlier testimony, part of what I believe is important is simply building a rapport with an individual. Again, you always have with any individual in any interrogation, there's the natural barrier that can occur with them seeing you as a law enforcement officer. I've been doing this job for 18 years. That was not intended on any way on my part to suggest to Mr. Brooks that everything his girlfriend was saying was a lie. I just wanted him to feel comfortable telling me the truth, whatever that truth was, man to man or person to person, human being to human being.
Lying.
Directing your attention to 30 minutes and 26 seconds and playing this clip until 40 minutes and 30 seconds. Let's do that now.
Objection. Wasn't it just said we was 15 minutes in the interview? Why is it playing from 30 minutes?
Your objection is noted. It's overruled again. That's 30-26, you said?
30-26 to 40-30.
To 40-30. Go ahead.
No. What brought you to Waukesha yesterday? How did you get out here?
I was meeting up with a friend to watch the Packer game.
Okay.
That's the only reason why I was out here.
Where did you go to watch the game?
To a friend named Stephanie.
Her house, a bar, or?
A house.
Yeah, I don't mean to make you uncomfortable or anything, but what's the address there? What's
I have no idea about Waukesha. I don't know the streets.
What was it near? I know you had to see something near it. So what was it near?
Like a gas station.
Have you been to the house before?
No.
Never before?
No.
What's Stephanie's last name?
I have no idea. I have no idea.
When did you guys set this up?
Maybe a couple of days ago.
Okay.
Like I said, I have a few friends. I have a few friends in Milwaukee that have people out here, so
okay.
It's not, like I said last night, I don't know the streets in Waukesha. It's not where I usually hang out at, so I couldn't say, well, this street, and this, I couldn't.
All right.
Stephanie, like a friend of yours or like a friend of a friend?
A friend of a friend, mutual friend.
And what did you say her last name was?
I have no idea.
How long have you known her?
That was my first time meeting her. So
how did you get the number to know the house to go to?
A friend.
So how did you get to her house?
My friend. I went with my friend.
Okay, who's that?
My friend, I don't really want to say his name. I don't know if that's going to incriminate him in anything. So.
Okay, so let's go with this. How did you come? I know you saw Erica yesterday in Waukesha because we talked to her. Now, I don't know everything that went on, and I'm not saying I believe everything she told the other officers. How did you come to meet with her in Waukesha, one? And two, you say you don't know Waukesha, but where did you meet her? A gas station, a park? I know you met her. Where did you meet her? What happened yesterday?
Yeah,
because if this is BS, like you say, and I know you met her, what happened? What happened when you met her? Where did you meet her? Let's start with that.
By a gas station.
Okay.
I don't know what I was supposed to be getting some money from her.
Okay. For what?
It was the rest of my money that she had of mine that she was holding for me.
Okay, how much?
It was supposed to be $350.
Okay. And what Why did she have it? Why was she holding
Well,
it?
she had been holding it for me for a few weeks now, but like I said, I hadn't seen her. She had seen
Right,
my
but
mom
what was she
already.
holding? Why did she have it? Why was she holding it for you?
She was just holding it for me because I told her to hold it for me. But it didn't have anything to do with, this was weeks ago. She had been holding the money. And because I had no contact with her, I couldn't tell her, and my mom wasn't going to let her come to the house to bring it.
Mm-hmm.
And I told her, look, man, if I'm going to be out there, I'll meet up with you and get the money, but I'm not hanging out with you. I'm not having sex with you. And she was just like, I'm like, I'm not finna do none of that.
Okay.
You know what I'm saying? I'm not supposed to be around you.
So who is the friend whose phone you were using to talk to her on a three-way call?
I don't want to say his name because I don't want to.
Okay, I guess, so you saw her though, right? You met up with her? Okay. So, how did the conversation with her end?
With me walking off and her being pissed off that I didn't want to hang out with her. I said, look, I'm not supposed to be around you, I'm gone.
Okay.
When she
Whose
said,
car did you use to get out
she
here?
said, I didn't have a car.
No, whose car did you use to get to Waukesha?
My friend is the one that said he was going to go hang out and watch the Packer game. I said, I'm going to go with.
Okay. Whose car did you use to get out to Waukesha?
I didn't use anybody's car.
Where does your friend live?
My friend lives in Milwaukee.
So, you didn't walk to Waukesha. Whose car did you guys use to
My
get
friend,
out?
I just said my
What
friend.
type of car is he?
I'm
just trying to figure out how you got here.
Yeah, I know, but it seemed like you trying to, like, spin me up or something. Like,
I'm just asking how you got here. Whose car did you drive out here?
I didn't drive at all.
Whose car did you come out here in?
My friend.
Okay, right. What kind of car is it? So here's the thing, Darrell.
Okay.
Obviously, you know, she's coming at us. I told you she's talking about some domestic-related issues, okay? You know, and I don't know if she's on BS. I don't know if she's not.
I'm telling you.
Hold on, let me finish. Let me finish. I don't want you to get...
Yeah, because...
Hold on, let me finish. You know, I don't entirely know all that, okay? I'm just right now trying to figure out how you get out here. So, I got to step out with my partner for a minute. Just relax. I don't want you to get you all nervous, okay? But, you know, I'm not trying to be confrontational, but I don't think when you meet her out in Waukesha, and you're not from Waukesha, I think a reasonable question is to ask, how did you get out here?
Yeah.
Whether you drove, someone else drove, and if so, when you got out here, what type of car you were in. So just, every hour or so, my boss, he knows we're out here. I just got to call him and say, yeah, we're talking. I'll call you back later. Just got to step out, throw in a line with him, and we'll come back. Just chill out here, enjoy your soda. We'll be right back. All right? Sound good? Okay.
So we done talking or?
No,
come back.
Just chill out, and we'll be back.
You just gotta make that
back in that cell. I just got to make that call.
That check-in call.
All right?
In the middle of the conversation?
Well, do you want to tell me about the car?
Just go another couple minutes.
Yeah, but I
I got to call him. I can come back, but I just...
Listen, I'm willing to listen, Carpenter. You've been straight up with me. You've been straight up with me, right? Mm-hmm. All I'm saying is I just want to know what I'm looking at and if I can just notify my girls. That's it. I don't have a problem with talking to you guys at all. I just want to know what am I looking at. That's
Well,
it.
at the start, she called about some domestic abuse-related stuff. Now, I didn't talk to her myself. I told you that at the start. You said she was crazy. We talked
Y'all
about
know that. Y'all talked to the woman.
No, I didn't.
Oh,
Other
I
officers-
apologize. You talk.
Other officers that we listened to the interview.
Slow down, Darrell.
Did she look beat up? Did she look like, dude?
Darrell,
Like,
listen
come
to me.
on now, man.
Slow down, dude. All right? We can't explain it to you if you keep talking over us. You know what I'm saying? All right? I didn't talk to her. I didn't see her. Okay? Now,
We have a lot of talk about her, meeting her. Who is her?
Objection leading.
Overruled.
The her in this case is Erica Patterson.
So did you have some conversations with Mr. Brooks before this clip about his relationship with Ms. Patterson?
Objection leading. I do consent to being called that name.
The objections are overruled. The witness may answer.
Yes, I did.
Now, at the end of this video, not the end of the video, but the end of this clip, again, he is saying, "What am I looking at?" Do you recall him saying that in this video?
Objection leading.
Overruled.
Yes, I do.
Was this a theme throughout this 5-hour video?
Objection leading.
Overruled. The witness may answer.
Yes, it was.
Did he... You had stated initially when he came into the room he had complained about some shoulder pain.
Yes, he did.
Did that continue throughout the interview?
Objection relevancy.
Overruled. The witness may answer.
So I would say what happened is it went on and off. So at this point here, the interview at this point in time was what I would describe as laid back. A lot of it was simply getting background about the overall relationship between Mr. Brooks and Ms. Patterson. During that time, he was fine. He was moving his arms, as you could see in this clip. He wasn't complaining about pain. What I noticed and made me question the legitimacy of the injury before ever actually even seeing the body cam is I noted at times of stress later in this interview as I continue to push on a vehicle. I can see, as you could see here, I believe it can be seen here in this interview, talking about the car made him uncomfortable. Complaints about the pain would suddenly come back.
How about the request to be told what he's looking at? Did you see any correlation between that and what was occurring during the interview?
Objection speculative.
Overruled. The witness may answer.
Yes, that, as I say, that continued throughout the entirety of the interview, and really at this point was a little unusual because right now he had been told he was looking at the domestic. The parade hadn't come up, so a reasonable person, I believe, at this point of the interview knew what they were looking at. They were looking at a domestic abuse incident. Why simply asking him how he got out here as far as transportation made him nervous was alarming.
An example of him, you said that you had seen him using his arms a little bit in this clip, is that correct?
Objection leading.
Sustained as to the form of the question.
You had stated that, what observations did you make during this clip about the use of his right arm?
He would move it from side to side, so, I mean, both his arms would come out like this and move. He would make mannerisms when he was speaking with both arms that were, to me, what a person would do when they're normally conversing. And it would seem unusual to make those movements if he was, in fact, in as much pain as he was claiming to us he was in.
Now I'm going to just let the record reflect that when you had indicated he'd move his arms this way, you moved both your right and left arm out parallel to the ground at about shoulder level. Would that be accurate?
Yes, it would.
I'm going to show you a clip beginning at 52 minutes and 15 seconds to 52 minutes and 42 seconds, so a very short clip.
Go ahead.
That, and then she makes this complaint when she gets you back.
Yeah, and it's like, why do you do this to me? And I promise you, my right hand to God Almighty on the throne with Jesus next to his side, the woman is going to sit up there and say, I was drunk, I was mad, blah, 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 blah. But it's like, now I got to go through everything just for you to do that. Why did you do this to me?
So you think she's going to come back to us?
So we saw some motions with his arms during this clip. Would that be an accurate statement?
Objection relevancy.
Overruled. The witness may answer.
Can you explain to the jury what you observed?
So I observed Mr. Brooks move his arms to his side, above his head. his right arm almost fully above his head at points. Quite frankly, showing that arm seemed to have full range of motion.
Now, you had testified yesterday, you had seen a video or a still shot from a video, and you identified the defendant driving a red SUV. Do you recall that testimony?
Objection leading.
Overruled. The witness may answer.
Yes, I do.
And when the defendant was telling you about his friend bringing him out in a tan Kia, I think he said, did you believe that to be true?
Objection.
Sustained. It's for the jury to determine credibility. The witness will not answer that.
Did you ever see any video of the defendant driving in a tan Kia during the time of the parade?
Objection. Hearsay.
Overruled. The witness may answer that.
No, I did not.
Directing the video to 1 hour, 4 minutes, 30 seconds, and playing until 1 hour, 18 minutes, and 2 seconds.
Before we go to this clip, I know we have the witness, I've been told, and the interpreter available. So I would like to put further testimony and watching of these clips on hold. We do need to take a witness out of order in order to accommodate the interpreter that the court has arranged for. So, Detective Carpenter, you may be excused momentarily. And then if Mr. Ryan would accompany the witness, this will be Mr. Juan Marquez being called by Mr. Brooks. Yeah, Jen, can we I'm going to need that chair up there. Sorry about that. We can get another chair. And Mr. Brooks is calling Juan Marquez. Is that true, sir? Mr. Brooks, are you calling Mr. Marquez as a witness at this time?
Yeah.
All right, Mr. Marquez, if you would accompany the interpreter all the way to the witness stand. Ladies and gentlemen of the jury, I have an instruction to read to you. No matter what language people speak, they have the right to have their testimony heard and understood. You are about to hear a witness in which an interpreter will translate for one of the witnesses. The interpreter is required to remain neutral. The interpreter is required to translate between English and Spanish accurately and impartially to the best of the interpreter's skill and judgment. The evidence you are to consider is only that provided through the official court interpreter. Although some of you may know the non-English language used, it is important that all jurors consider the same evidence. Therefore, you must base your decision on the evidence presented in the English translation. You must disregard any different meaning of the non-English words. You must evaluate interpreted testimony as you would any other testimony. That is, you must not give interpreted testimony any greater or lesser weight than you would if the witness had spoken English. Keep in mind that a person might speak some English without speaking it fluently. That person has the right to the services of an interpreter. Therefore, you shall not give greater or lesser weight to a person's translated testimony based on your conclusions, if any, regarding the extent to which that person speaks English.
Good morning, Mr. Marquez.
Buenos días, señor Marquez.
You were at the parade on November 21st, 2021, is that correct?
Usted estaba en el desfile del 21 de noviembre de 2022, ¿correcto?
Es correcto.
That is correct.
And Do you recall who you were there with that day?
¿Se acuerda con quién estaba ese día?
Con mi esposa y mi hijo.
With my wife and with my son.
And were you marching in the parade that day?
¿Usted estaba caminando en el desfile ese día?
Sí.
Yes.
Do you remember who you were marching with? Was it
¿Quién
a
estaba caminando?
particular group?
¿Un grupo en particular?
Sí.
Yes.
Do you recall who that group was?
¿Se acuerda quién era el grupo con el cual estaba desfilando?
Sí.
Yes.
And at some point, you felt something hit your leg?
Y en un momento usted sintió que algo le pegó su pierna.
Es correcto.
That's correct.
And do you remember what that was?
¿Se acuerda qué fue?
Un vehículo.
A vehicle.
And did you see the vehicle?
¿Vio el vehículo? ¿Lo vio?
No.
No.
And were you interviewed by any law enforcement at that time?
¿Usted fue entrevistado por algún agente policial o policía?
Sí.
Yes.
Do you recall if it was regular officers or FBI?
¿Se acuerda si fue un oficial regular o fue la agente de FBI?
FBI.
FBI.
Do you recall telling them that the truck was black?
¿Se acuerda que usted
Grounds.
The objection is sustained. As to leading, please rephrase your question.
Do you remember what color you told them the truck was?
¿Se acuerda si usted se acuerda qué color dijo él? ¿Qué color la troca fue?
No recuerdo.
I don't remember.
So it would be fair to say you don't recall seeing anything at that time?
¿Se puede decir que usted no se acuerda de nada en ese tiempo?
No.
No.
And did you at any time file a claim related to this incident?
¿En algún momento usted archivó un reclamo con respecto a este incidente?
No recuerdo.
I don't remember.
Do you know if anyone you were with filed a claim related to this incident?
¿Sabe si alguien que la acompañó si ha archivado un reclamo con respecto a este incidente?
No lo sé.
I don't know.
Would you consider yourself an injured party in this incident?
¿Usted se considera una parte herida, lesionada debido a este incidente?
Sí.
Yes.
Any reason why you wouldn't file a claim since you considered yourself an injured party?
Por eso que usted se considera una persona no herida durante ese incidente. ¿Alguna razón por la cual no archivaría un reclamo?
There's an objection. It's sustained as to the form of the question. Please rephrase.
Por favor, diga la pregunta de nuevo.
¿Me puede repetir la pregunta?
There's an objection. You don't need to answer.
No tiene que contestar. Could you repeat the question, please?
Please rephrase, Mr.
Por favor,
Brooks.
diga la pregunta de diferente manera, señor Brooks.
That's kind of hard to rephrase.
Es un poco difícil si la pregunta de diferente manera.
Did you intend on filing a claim related to this case?
Objection.
¿De archivar un reclamo con respecto a este caso?
Hold on. There's been an objection. The ground.
Your Honor, first of all,
Primero,
This witness testified he doesn't recall filing a claim, so I'm not sure what the relevance then would be of the question.
The question was, did he intend to?
I'll sustain the objection as to the form of the question. Please rephrase.
Do you recall at any time filing a police report?
¿Se acuerda en un momento usted de archivar un reporte de policía?
Sí.
Yes.
And was that with local law enforcement,
Eso
if
fue
you recall?
la agencia de policía local, ¿sí se acuerda?
No recuerdo.
I don't remember.
Did any law enforcement from that report follow up with you at any time?
A una representante de una agencia policíaca hizo algún tipo de seguimiento con usted en ese tiempo.
Sí.
Yes.
Do you recall at any time being notified that you could possibly testify in this incident?
¿Usted se acuerda que en un momento que le notificaron que en un momento usted podría testificar sobre ese incidente?
¿Me puede repetir la pregunta?
Could you repeat the question?
Sure. Do you recall at any time being notified that it was a possibility that you could testify in this incident?
¿Se acuerda que en un momento podría, si le notificaron que habría sido una posibilidad que usted podría testificar con respecto a ese incidente?
No.
No.
Were you ever subpoenaed in relation to this incident?
¿Lo citaron alguna vez a corte con respecto a ese incidente?
Sí.
Yes.
Do you recall who you received this subpoena from?
¿Se acuerda de quién recibió el citatorio de corte?
Del distrito de la oficina del fiscal.
From the office of the district attorney.
And do you recall when that was?
¿Se acuerda cuándo fue?
Un mes y días.
A month and a few days.
And following being subpoenaed, or following, rather, to strike that back, after receiving the subpoena, did you follow up with the district attorney's office at any time after?
Después de recibir entonces el citatorio, ¿recibió algún tipo de seguimiento por medio de la oficina fiscal después del incidente?
Sí.
Yes.
Do you recall whom you spoke with?
¿Se acuerda con quién habló?
Susan.
Susan.
Would that be referring to Attorney Opper, who is seated at this table?
¿Se refiere a Susan Opper, que está sentado en esa mesa?
Sí.
Yes.
And were you at any time informed of a plaintiff in this incident?
Objection, relevance.
Sustained.
You don't need to answer that
No
question.
tiene que contestar la pregunta.
Were you at any time notified that there was a plaintiff in this incident?
Objection,
Grounds.
relevance.
The objection is sustained. The witness does not need to answer.
Do you even know if there's a plaintiff in this incident?
Objection,
Grounds.
relevance.
The objection is sustained. The witness does not need to answer.
Do you recall ever seeing, excuse me, do you ever recall, sorry. Do you recall ever seeing or reading a complaint in this matter?
Entonces, ¿cuál es usted vio, si leyó la acusación criminal en este asunto?
No.
No.
Going back to the actual incident, would it be fair to say that at the time you were very confused?
Volviendo entonces al incidente, ¿se puede decir que en ese tiempo usted estaba bastante confundido.
¿Me puede repetir la pregunta?
Could you repeat the question?
Going back to the time of the incident at the parade, would it be fair to say that you were confused at the time?
Volviendo entonces al momento del desfile, ¿se puede decir que usted estaba confundido en ese tiempo?
No.
No.
Any reason why you don't recall seeing anything?
¿Hay alguna razón por la cual que usted no se acuerda de ver algo?
¿Me puede repetir la pregunta?
Could you repeat the question?
Any reason why you don't recall seeing anything?
¿Alguna razón por la cual que usted no se acuerda de ver nada en ese tiempo?
No vi el vehículo.
I did not see the vehicle.
Solo pasó.
It just passed by. So the interpreter needs to make a clarification on his last response. If I can inquire. Cuando te dice que pasó el vehículo, ¿quiere decir que ocurrió el incidente o que el vehículo pasó por usted? Cuando usted dice pasó el vehículo o que pasó como ocurrió?
Ocurrió, me pegó y pasó rápido.
For clarification, the interpreter inquired if he meant the vehicle passed by or if the incident happened. The defendant, interpreter for clarification, the interpreter would like to say that he meant that it just happened, that the vehicle just hit him, rather than, I believe the interpreter translated what he said as it passed by. What he meant to say is that it actually happened, rather than passed by. So for that point of clarification, for the record.
Thank you.
Also, for clarification, just so we're clear for the record, you don't recall actually seeing the vehicle.
También, sí, vamos a estar clarificando por el acta. No se acuerda que vio el vehículo.
No.
No.
No further questions.
No más preguntas.
Any questions, Attorney Basie?
Briefly.
Brevemente.
Good morning, Mr. Marquez.
Buenos días, señor. Good morning.
On November 21st of last year, were you walking with the Catholic communities of Waukesha?
El 21 de noviembre del año pasado, desfilando con Catholic communities of Waukesha.
Es correcto.
That's correct.
Hold on. What was the objection?
¿Qué fue la acusación?
I mean, you already.
You have to speak up. I couldn't hear what you said.
I have a code, so I can't.
Mr. Brooks, was there an objection so I can move on?
Yes, there was
On
an
what
objection.
grounds?
I can't even remember now.
Well, if you were objecting on relevance, it's relevant. His answer may stand.
It wasn't relevant, so I'll tell you that.
Mr. Marquez, if you hear the word objection, please wait until I rule on the objection before you answer. Thank you.
Gracias.
Go ahead.
Adelante.
So we did answer the question?
¿Sí contestó la pregunta?
Sí.
Yes.
Thank you.
Muy bien, gracias.
You were with your wife and your son?
¿Estaba con su esposa y su hijo?
Sí.
Yes.
And your son's name is David Marquez?
Objection leading.
¿El nombre de su hijo es David Márquez?
Overruled. You called the witness. The state may lead. Go ahead and answer.
Contesta la pregunta, por favor. ¿Sí puede contestar?
What does that mean?
Go ahead and answer, sir.
Conteste, por favor.
Sí.
Yes.
You testified that at some point you were struck by a vehicle.
Objection.
Usted testificó en un momento que usted testificó que
Overruled.
fue pegado por un vehículo.
You may answer.
Puede contestar la pregunta.
Sí.
Yes.
Did you have any warning before you were struck by the car?
Objection.
Tipo de advertencia,
Hearsay.
de aviso antes que fue chocado por el carro. Me pongo de evidencia por referencia.
Overruled.
Anulada.
The witness may answer.
Puede contestar la pregunta.
No.
No.
Did you hear a horn honking?
¿Escuchó
Objection.
una bocina, un claxon?
Hearsay.
¿Está sonando el vehículo? ¿Un claxon?
Overruled. The witness may answer.
Puede contestar la pregunta.
No.
No.
Sir, I'm going to show you what's been marked as State's Exhibit 161.
161.
Go ahead.
Adelante.
Can you see that picture on the screen in front of you?
¿Pantalla frente a usted? ¿Lo ves la imagen?
Sí.
Yes.
And do you see the approximate area where you landed after the vehicle struck you?
Usted fue el área aproximado.
Objection leading.
Después de que el vehículo
Overruled. The state may lead. It's not their witness. Go ahead and answer, sir.
Adelante y conteste, por favor.
So I can lead too if it's not my witness?
No. Well, hold on. We'll get to that later. There's been an objection. I'm overruling it. Go ahead and ask your question.
The state can do what they want.
Do
Got it.
you see the area in which you landed after the vehicle struck you?
Después de que el vehículo lo chocó.
Sí.
Yes.
I'd ask that this exhibit be admitted to evidence, which is 161, and published to the jury.
Objection.
Obrigado. Entonces, 161.
We can't even see who's what exactly is the state referring to.
¿Qué se refiere al Estado?
You can't even see who it is.
No veo quién es.
Just state your objection.
¿Y su
It's
oposición?
overruled
Anulada.
Of course, it's going to be overruled.
because it's attempt to testify. But if the state could just ask a few more foundational questions, please.
Certainly. When you met with the state, did you review some video of the parade?
Objection. Hearsay.
Me pongo evidencia por evidencia.
Overruled. The witness may answer.
No puede contestar.
Sí.
Yes.
And after reviewing that video, were you able to determine the area in which your body landed after you were struck by the car?
Objection. Hearsay and leading.
Overruled as to both. You may answer, sir.
Después de que entonces se recibió entonces el choque del carro, determinó el área. ¿Se acuerda dónde su cuerpo quedó después de que el vehículo chocó?
Sí.
Yes.
And do you see that area on this exhibit?
Objection leading.
Overruled. The witness may answer.
Sí.
Yes.
I'd ask that this
Every objection.
exhibit be admitted to evidence and published for the jury.
Objection. What's the relevancy?
The objections are noted. They are overruled. And Exhibit 161 is received. Permission to publish is granted.
And it's indicated that that is now being seen in the jury box. Sir, the screen in front of you is a touch screen. Can you circle the area in which you believe you landed?
Objection leading.
Overruled. The witness may answer.
How do you say where they believe? Either you know or you don't.
The witness may answer.
Sí.
Yes.
Ridiculous.
Can you do that now?
Puede ser eso, entonces marcar el lugar donde se cayó.
That's where it gets fixed the whole thing.
If we can take a snapshot of that.
I don't know what Mr. Brooks just mumbled, but it's not his turn to ask questions. There was no objection. The jury will disregard that.
And this would be Exhibit 161A.
And we'll screen capture that. Exhibit 161A has been captured. Are you moving that in?
I am.
And Exhibit 161 is received. 61A.
Thank you. And do you see anyone that you recognize standing in that area?
Objection leading.
Overruled. The state may lead. It's cross-examination of your witness,
So
sir.
I can lead on cross-examination then?
I direct your attention to 906.11 sub
Can I
3,
lead
sir.
on cross-examination?
I'm not going to answer that. Go ahead,
So
sir. You may
just your
answer.
determination that you don't have to answer that? If I don't understand something?
The jury will disregard the comments being made by Mr. Brooks.
Judicial determination, okay.
Go ahead and answer the question if you recall it, sir.
¿Me puede repetir la pregunta?
Could you repeat the question?
Yes. Do you see David, your son, in that picture?
Objection. That
Sí.
way.
Yes.
And is he wearing?
So my objection is not going to be noted.
The objection is overruled. The state chose to ask a different question. That's fine.
And is he seated near some blue chairs wearing a blue jacket?
Objection leading.
Overruled. You may answer, sir.
Sí.
Yes.
And sir, is that you laying down, and you can see in this picture your legs and they're hanging into the roadway?
Objection leading.
Witness may answer. Overruled.
Sí.
Yes.
Now, is that where you were walking when you were struck from behind?
Objection
in that
leading.
position?
Overruled. You may answer.
No.
No.
How far from the position that you recalled yourself to be at when you were walking did you land?
Objection leading.
Overruled. You may answer.
Me opongo de evidencia por evidencia anulada. Puede contestar la pregunta.
Entre 15 a 20 pies.
Between 15 and 20 feet.
So your body flew through the air between 15 and 20 feet. Is that what your
Objection
testimony
leading.
is?
Sí.
Yes.
Sorry, I didn't rule on the objection, but it is overruled and his answer may stand.
Was David also struck by a vehicle during the parade?
Sí.
Yes.
Did he received injuries as well?
Objection relevancy.
Overruled. You may answer.
Sí.
Yes.
Can you describe what your injuries were, sir?
Objection leading.
Overruled. You may answer.
Anulada. Puede contestar.
Sí.
Yes.
What were they?
¿Qué fueron sus
Objection leading.
Overruled.
Pongo pregunta insinua. Anulada.
La fíbula
My fibula
y ligamentos.
and ligaments.
Your fibula was broken?
Objection leading. Speculative.
Overruled as to both. The
That's not
witness
what
may
he said.
answer.
Sí.
Yes.
And you had torn ligaments?
Objection leading.
Overruled.
You didn't say that in the question before.
Sí.
Yes.
And were those both in the same leg?
Objection leading.
Sí.
Sorry,
Yes.
overruled. If we
Of course.
just wait when there's an objection. I'm overruling it. It's relevant. It's not leading. The witness's answers may stand.
I mean, yeah, you overrule every objection.
And the jury will disregard the additional commentary made by Mr. Brooks at this time.
Judicial misconduct at its finest.
And which leg was that, sir?
Objection, asked and answered.
Overruled. You may answer.
Puede contestar la pregunta.
El pie izquierdo.
My left leg.
Did you have to have surgery on that leg?
Objection leading.
Overruled.
Anulada.
Sí.
Let's
Yes.
see what y'all
Just
trying
one?
Nada más una cirugía.
to get here.
Dos.
2.
That's not gonna work either.
Mr. Brooks, you are advised to stop with the commentary.
No, I'm gonna say what I want.
You
to say.
called this witness. I'm going to take a break right now and excuse the jury and this witness.
All right.
What you doing is judicial misconduct. Judicial misconduct. But you don't want the jury to hear the truth. That's not fair to the jury. They have a right to hear everything. Not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
Mr. Brooks, please stop.
No, ain't no please.
You are
nothing.
being disruptive.
Ain't
You
no
are being
please, nigga.
disrespectful.
You always
The
gonna
witness
find
may
some
step
reason to
down.
somebody's being disruptive because they want the truth to be out there. Man, quit it. You're supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be present in this courtroom.
Under what law and fact can you do that?
Illinois versus Allen.
Okay,
sir.
but the fourth option that you made up, that's not even in the law?
Mr.
Because
Brooks,
you can't do that.
I need to make a
By law,
ruling.
you can't do that.
I need to
And
make
you
a
know you
finding.
can't.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom. He will continue in the neighboring courtroom. Please make sure he has his objection signed and a pad of paper.
So is that
he can.
So is that holding me in
meaningfully
contempt?
participate, and I will make a ruling when I.
So are you holding me in contempt? Is that civil or criminal?
The record, Mr. Brooks has been removed to the other courtroom. The jury is not present, and the witness that was on the stand is also not present in the courtroom.
Actually, he is, Judge.
Oh, all right, then we'll have
Step him
him removed. Thank you. Thank you for that clarification. I didn't see him seated all the way back behind a couple of individuals. So this morning, Mr. Brooks, prior to the court removing him, had interrupted the court approximately 10 times prior to 10:19 a.m. Then, of course, he was removed. This does not include the repeated commentary, either under his breath but still audible for the court to hear, the jury to hear, and witnesses to hear, related to a variety of topics, including subject matter, jurisdiction, misconduct by the court, disapproval with the court's rulings. This very last witness was a witness called out of order at the request of Mr. Brooks. As I know the attorneys are well aware, and certainly this court is well aware, under 906.11, the court shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following: make the interrogation and presentation effective for the ascertainment of truth, avoid needless consumption of time, protect witnesses from harassment or undue embarrassment. That's all under sub 1. Sub 2, scope of cross-examination. A witness may be cross-examined on any matter relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. I frankly haven't exercised my authority under that particular subsection. I have generally relied upon sub 1. In addition, sub 3 says the following: leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. And during the cross-examination of this last witness, Mr. Brooks objected almost without fail, if not without fail, to every single question asked by the state on grounds of either leading or relevance. And then when the court overruled the objections, as time went on, it seemed to me that his commentary became much more audible. He was muttering under his breath and clearly showing disrespect for the court and the proceedings. In my opinion, they're baseless objections. Again, because this witness was brought into court on a subpoena that was from Mr. Brooks, served, of course, by the state to assist with him in that regard. But the state was well within its rights to ask leading questions. It's this court's opinion that the repeated interruptions by way of baseless objections is to disrupt these proceedings, disrupt the testimony of the witnesses, and in particular, Mr. Marquez. This court has been abundantly patient this morning, noting the repeated interruptions by Mr. Brooks starting right away at 8:31. There were a couple of interruptions, continuing at 8:37. At 8:48, I think we had a total of 5 more at that point or so. At 8:49, and then of course at 10:19, this court removed him under its authority in Illinois versus Allen. I also had warned him, or at least at times I would give the jury an admonishment, not really an admonishment, but an instruction, please disregard the commentary by Mr. Brooks. It's been very apparent that any time this jury is brought in or taken out, Mr. Brooks begins making statements that are misstatements of the law, or generally his disagreement with whatever is going on at that particular time, accusing the court of either bias or misconduct, accusing this court of hiding information from this jury. This court is not doing any such thing. I will make a finding that based upon the conduct of Mr. Brooks, that he has forfeited his right to be present during the cross-examination and any redirect of Mr. Marquez. Mr. Brooks's conduct has been anything but respectful today. It's been disruptive. As this court was stepping off the bench, he made some type of statement about contempt. Are you finding me in contempt? This court is well aware that one of the permissible ways to handle a defendant who shows flagrant disregard in the courtroom for elementary standards of proper conduct is to find a defendant in contempt. However, I'm not dealing with a defendant who is out of custody. I'm dealing with a defendant who is in custody on very serious charges, including, if convicted, facing the possibility of life sentences without the possibility of extended supervision. It is my opinion that finding him in contempt is not really a viable alternative to this court. Frankly, it would, in my opinion, it would serve to give the defendant, let me restate that. In my opinion, if this court were to find Mr. Brooks in contempt, it would allow him to profit from his own wrongdoing because it would result in a delay of these proceedings. I would have to, of course, make certain findings. One of the possibilities for contempt is to hold him in custody until such time as he's willing to abide by the rules. That is just not something this court is willing to even do because it would delay the proceedings. I am aware that that is a option identified by the Supreme Court in Illinois versus Allen, but I would remind the parties once again that Illinois versus Allen was decided in 1970. Certainly the technology that we have available in this courtroom was not something available to the parties in Illinois versus Allen. We have a very new state-of-the-art courthouse that I am operating out of. I'm in courtroom 13. Next door is courtroom 20. These are just the room numbers that I'm referring to. As you can see, we have the ability to see and hear into that courtroom, and that courtroom has the ability to see and hear into ours. I will confirm with the bailiff and the clerk that the audio is working. I'm told that it is from my clerk. With that, I would like to have the jurors brought in. I'll have the witness brought back to the witness stand with the assistance of the interpreter, and the state can continue with its cross-exam of the witness called out of order, but on behalf of Mr. Brooks. And I am getting verification from the bailiff in the other courtroom through my bailiff here that the audio and video is working as it should. Would also like to point out that there are headphones at the table in front of Mr. Brooks should he choose to wear them. He has not worn them in quite some time. Previously made reference to needing it when he was in the other courtroom, so they are there and available. All right, would Mr. Marquez and Interpreter Ryan please take the stand? He'll have the jury brought out. And just for the record, I will certainly let Mr. Brooks know he can ask to come back in when he's willing to abide by the rules of decorum and courtesy. The record should reflect the jury is being brought back in. Thank you, everyone. Please be seated. The record should reflect that Mr. Brooks is appearing from another courtroom. That should not affect the jury's verdict in any way. The state may continue with its cross-exam of this witness.
The state would have nothing further.
All right, Mr. Brooks, do you have any redirect for this witness? Mr. Brooks, do you have any further questions for Mr. Marquez? The record should reflect that Mr. Brooks is reading out of a book. He has not answered the question. I will ask one more time. Sir, do you have any further questions for Mr. Marquez?
Am I unmuted?
You are. You have been.
What's going on?
Do you have any redirect questions for Mr. Marquez? This is your opportunity to ask any follow-up questions that you have for this witness.
Say something. I'm trying to see if the headphones on. It's supposed to be on a certain channel. Can someone say something from the other courtroom?
Any questions for Mr. Marquez at this time? It's your opportunity to ask follow-up questions. The state indicated it did not have any additional questions.
Nope, I don't got no follow-up question.
All right, thank you. Then, Mr. Marquez, you may step down. Thank you for being here today. All right, I need to excuse the jury momentarily. Please rise for the jury. All right, thank you. Be seated. Mr. Brooks, under Illinois versus Allen, which that case clearly tells me to do that, once lost, the right to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. The court is going to continue with the direct examination by the state of Detective Carpenter. I would like you to come back to this courtroom. Are you willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings?
I didn't do anything to be held in contempt in the first place.
So are you willing to abide by the rules of decorum and civility? I would direct your attention to SCR Chapter 62, which has been provided to you previously.
Does that say anything in there about me being held in contempt?
That does not, no.
So why have I been held in contempt?
I didn't hold you in contempt, sir. You are simply in a different courtroom based upon your disruptive behavior. I'm giving you the opportunity.
Has not been disruptive.
I've put my findings on the record, sir, and the record stands in that regard. I'm giving you the opportunity, if you can, indicate to this court that you will conduct yourself with courtesy and decorum. Are you willing to do that, sir?
Is Your Honor willing to tell me why I've been held in contempt?
I did not hold you in contempt, sir. I've already indicated that.
Removing me from the courtroom is like holding me in contempt.
I didn't hold you in contempt. You were removed pursuant to the authority given to me by the United States Supreme Court in Illinois versus Allen, based on your disruptive behavior.
My behavior wasn't disruptive, Your Honor. The record should be corrected in that. And as I recall you stating before, or not you stating, but us having a conversation about Illinois versus Allen, for the record, at one point, I got the date in my notes that we had it, where I said on the record that there were three options identified. And
Mr. Brooks, I'm not going to have a debate with you on what the law means and whether you understand it or not. I'm simply asking you whether you are willing at this time to abide by the standards of courtesy and decorum that are outlined in SCR Chapter 62 and that are inherent in the concept of courts and judicial proceedings, including making proper objections based upon the rules of evidence, based upon the rules of procedure, based upon the law, that you will not interrupt when you disagree with a ruling made by the court, and that you will generally conduct yourself with dignity and decorum.
But is it not my right? Is it not my right to object?
I'm going to ask Mr. Brooks one more time if he would like to come back to this courtroom and if he's willing to conduct himself with dignity, respect, and decorum.
But for the record, I don't consent to being called that name. My name is Darrell Brooks Jr., and I never stated that I wanted to be removed from the courtroom.
All right, I'm going to mute Mr. Brooks. He is clearly not answering my question. And given his recent conduct, I'll indicate he continues to forfeit his right to be present based upon the prior disruptive conduct. I have given him 3 opportunities to answer the question, would you like to come back into the courtroom? And in other words, to reclaim his right to be present. He has chosen not to answer that. I understand he disagrees with the characterization by this court of his conduct, but my ruling stands and the reasoning for my ruling stands. What I will advise Mr. Brooks is once the jury is brought back out and once the witness is back on the stand, I will unmute him so that he can properly object, and then I'll rule on, of course, any objections. I certainly reserve my right to use the mute function of the audiovisual capabilities that I have should that right be abused. So with that, why don't we have Detective Carpenter come on back to the stand. The jury is advised to come out.
Your Honor, I know you previously ruled that if Mr. Brooks wanted to come back into the courtroom, he could signal to a bailiff in the courtroom that he's in, that he believes he can.
Yes, thank you. He may absolutely signal to the bailiff, and then they can get that information to me, and I will promptly stop and we'll have him brought over. Thank you for that.
Thanks.
That invitation is an open invitation. He wants to come back? All right. The witness can stay here. Please have the jury remain. We'll have to clear the courtroom so he can be brought back in. We'll be in recess for that. Back on the record, and I've advised to have the jury brought out. I'm glad you're back here, sir.
Are you, Your Honor?
I am, sir, actually.
I'm not too sure. Especially when I bring up subject matter jurisdiction.
I've ruled on that, sir.
I know, but it hasn't been proven for the record.
If you disagree with my ruling, sir, you can file an appeal.
It has to be proven on the record. Has yet to be proven on the record.
I disagree, sir. You can have a sheet. All rise for the jury, please. Seems to me it's hotter in here, too.
Yeah, it's kind of schizo.
Thank you, everyone. Please be seated. All right, at this time, the state may continue with its direct examination of Detective Carpenter. And let me know if you need the audio visual right away.
I will.
Okay. You want it? It should be coming on.
Sir, regarding the interview, we've been playing a couple snippets of the interview with Mr. Brooks from Exhibit 82 that took place on November 22nd of last year. I would now direct the juror's attention to 1 hour, 4 minutes, 30 seconds.
Objection, I don't consent to being called that name for the record.
Noted.
And I'd ask that be played till 1 hour, 18 minutes, and 2 seconds.
It's noted, but it's overruled. Go ahead.
Thank you.
So, what's your buddy's name? Can we get that? If we gotta talk to him to verify you're on the up and up and she's on some BS?
His name is Marcus.
What's his last name?
I don't know his last name.
What's his phone number?
467. Oh, wait, hope if I have my freaking phone somewhere. 467. 85 31 or 30 or something like that.
112?
Yes, sir.
And he lives in Milwaukee?
Yes, sir.
And you guys came out here together?
Yes.
Okay, so he is.
Well, like I said, Stephanie was. She's a older mixed lady, so she's not. You know, she.
Who do you know in Waukesha other than her?
I know a guy named Terrion. I met
Terrion live.
I don't know where he lives now. I've been knowing him for maybe 5-6 years. I just know he stays in Waukesha. He comes down to Milwaukee a lot, and then he comes back up here.
How old is he?
Like 34, 35.
34. Where did?
Maybe.
I know a
lot of females.
Well, how many times have you been to Terrion's house?
Once in like 2018.
Do you remember?
It was like an apartment. It wasn't a house though.
Apartment?
Yeah.
Do you remember what was near it?
I think it was like right on the main street.
What's the main street? There's a lot of streets. Like is
whatever
it
street
downtown.
What would be considered downtown?
Where all the bars and restaurants and
It's like a
shops are.
business district. Is Stephanie's place near downtown? Is there a bunch of bars and a business district right near there?
The only thing I can remember is a gas station, like a kitty quarter gas station. I think this street is like a one-way. Whatever street is right here is like a one-way, and it's a gas station like right here.
Remember what kind of gas station? With the Mobile Speedway, Quick Trip, Hometown.
Not a Quick Trip. Not a Speedway. Like the blue and white one.
Blue and white. Any schools or parks nearby your house? Something like that? Anything you remember like that? Trails?
I know that park. I know that park is by old girl's house.
By whose house? Stephanie's?
Yeah.
Park. What?
I don't know the name of the park, but it has like a little creek or. It was something going on out there yesterday to where a lot of shit was blocked off.
What was the name of the park?
I don't know. I know that park. I don't, like I said, I don't know about Waukesha, I don't know, but it seemed like everybody was at that park kind of walking around that creek.
Like a playground type park, or like a
park. It seemed like a little creek or something. Well, I don't know if you would say a creek. What would that be? But
river?
Would that be a river? Does Waukesha have a river? Well, I know it's just a small body of water. It's like, how would I describe it?
But there were barricades blocking some shit off near there?
No, it looked like in that area.
In that area?
In that area, it looked like a bunch of was like blocked. You couldn't go down certain streets or something. I don't know, but that park is close to the old girl's house, where that's why I said, look, when our friend was like, you know, your baby mama trying to get in touch with you, and I'm like, what's up? What's she telling you? What's going on? And she was just like, well, she said she got some money for you. And I was like, why would she tell somebody else? That's what I started thinking at first. Like, that's like, why is you think? Because she'll tell me the same thing. Don't tell people our business. So then when she put us in, when she merged us in, you out here. I'm like, man, yeah, but I'm like, what's up? Like, yeah, okay, cool. You gonna fit? No, not staying out here like that. I'm watching the game and I'm gone.
So she tell you where to meet, or you tell her where to
She
meet?
told me where to meet. I said, it's a gas station right here. And she was like, is it a park right there? I'm like, I don't know. Is it a park right here? They like, yeah, there's a park right down here, blah, blah, blah. I'm like, well, just meet me over there. I'll get the money from you, give you a hug, give you a kiss, and, you know, I'll call you later or whatever. It wasn't supposed to be us hanging out, spending time together. It wasn't that. It wasn't supposed to be that. She got mad because I didn't want to do that. That's why I kind of figured, but like I said, I didn't see her drink. I'm not going to sit here and say I saw her drink. I'm not going to lie on her. I didn't. But when she started acting like, yeah, you finna, that's when I kind of was like, she probably been drinking. She probably haven't just stopped drinking, but you was drinking sometime today. I know you was drinking sometime today. I didn't tell her that. I said, yeah, because she's acting too, you know what I mean? Oh, you just think you finna get the money and leave, and you must got something waiting on you, and blah, 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 blah. I'm like, see, this is why. This is why I just should have just watched the game and left, dude. Like,
all right, so
the fuck, man.
So you came out. How did you get out here again?
My friend.
What type of car does he drive?
Oh man, it's like a Kia type of car. I don't know if it's a Kia, but it's a small 4-door car like that, in that type of model.
Okay. What color is it?
Like tan.
And was it just the two of you that rolled out together? Did anyone roll out from Milwaukee with you?
No, it was just us two.
Two of us.
He said there probably was gonna be some chicks over there. You know, like I said, the Stephanie girl is an older woman. She, you know, likes to party, drink, you know, watch the game. She cooks. Fuck it, let's watch the game. I was only gonna probably go to my mom's house and watch the game there, and my mom has to go to work. So I was just gonna be sitting there like this. Might as well go, you know what I'm saying?
Did he offer to drive?
And at the same time, cool, I can get the money from, you know, that she been holding for me.
Yeah. Did he offer to drive? Do you have your own car? Did he offer to
no,
drive?
No, I don't.
How did you guys come
I don't own a vehicle.
Don't own a vehicle?
Nope.
Do you have any car you can drive at all?
No. I have license.
So you have a...
I do have license, but no vehicle.
Don't ever use your niece's, nephew's, mom's car or anything like that?
My nephew doesn't have a vehicle. My niece is 14.
What about your mom?
No, my mom doesn't even know how to drive.
She doesn't have a car, doesn't know how to drive?
She doesn't know how to drive.
Does
she never learned.
Okay. Does she have a car that she lets you use at all?
No.
Does she have a car at all? Maybe not that she lets you use.
No.
Does she have a car in her name at all?
I think she did at one point.
Does she right now?
Not that I know of.
Okay.
I'm not gonna say no because I don't know. I honestly don't know. Me and my mom we was kind of having family issues for a while, so we didn't talk for a while. She catches the bus to work, which I don't like her doing because Milwaukee. So she has to go. She works at Freighter, so she has to go. The way her bus route goes, she has to go way up to like 92nd. Then somewhere she told me they don't even have a bus depot thing. Mm-hmm. So it's getting cold and it's dark out there, and she's just standing out there. And I was just like, damn, I don't want. So I'm like, you probably gonna have to change your route to catch the bus from downtown Milwaukee on Wisconsin Street, downtown Milwaukee, and then go up because I don't like her.
Sure.
Yeah, I don't like her doing that.
So you just argued a little bit, and then you're saying you walked away yesterday.
Yeah, I just told her. I'm not finna freaking. It was people out there.
So, I might have missed this. You touched on it. You were at the gas station or the park? I know the park's nearby. You met her at the gas station?
The gas station. No, I met her at the park. The gas station was by the area that we were in. The gas station is by that park.
Yeah, I'm just clarifying.
Yeah.
Okay.
Which car were you in when you met her at the...
I didn't meet her in the car. I walked right over there. I walked right over there to the park, and she was standing like right wherever this entrance to this park is. Like I said, it was people everywhere. So anybody would see us standing out there. She was standing right there waiting for me. I walked up, gave her a hug, and she was just like, well, my friend has my purse, so I don't have the money and all this. I'm like, so you had me come way out here?
Like a power play or something?
That's basically was like, yeah. Okay. You know, you basically, you see how fast you caught on to that, and I was just like, you had me come way out here. You know, I ain't even supposed to be around you like that. You had me come way out here to meet you, for you to try to play like this. I said, no, man, I'm gone.
Yeah.
So I'm out.
It was daylight when you met up with her. Was it still daylight pretty much when you walked away from her?
Yeah, it was daylight the whole time. This was broad daylight. That's what I'm saying. Like, people outside, everything going on, people walking around the park. I'm like, anybody would have saw us talking. Anybody would have saw if anything happened.
Sir, with regard to this clip, you asked the defendant about his phone, correct?
Yes, I did.
Did you know where his phone was when you asked him if he lost it?
Objection. Hearsay.
Overruled. The witness may answer.
The phone was found inside the vehicle, so he didn't have it with him when he was taken into custody. The red Ford Escape.
Overruled. The witness may answer.
I'm sorry. The red Ford Escape.
And in whose name was that car registered?
Dawn Woods.
And what relationship is Dawn Woods to the defendant?
Objection. Leading.
Overruled.
She is his mother.
Did you question about the phones? What significance, if any, did that have to you? Or why did you ask him about the phone? Strike the initial question. Why did you ask Mr. Brooks about the phone?
Objection. I don't consent to being called that name.
The objection's overruled. Go ahead, you may answer.
One, to verify his contact information, but two, one, if we were to find the phone, it would help us know whether it is his. And if we were able to find a phone and we know it's his, knowing the phone number, including make and things of that nature, can help be used in location services at a later time to further verify that the suspect was, Mr. Brooks, was in Waukesha at the time when these incidents occurred.
And again, at the time that you asked these questions, did you know that the phone had been located in the car, or you did not have that information at this time?
Objection. Leading.
Sustained as to the form of the question.
What information at the time that you asked Mr. Brooks about the phone did you have about it?
Objection to the name.
Overruled. You may answer, sir.
Very little. At that point, I don't recall if I knew that the phone was inside of his mother's vehicle.
Okay.
Family, you know what happened yesterday for the people. Tell me what happened.
With what?
With the car.
What am I being
With your
investigated
mom's
for?
car. You were driving goofy, people called you in, you drove out of there in your mom's car, the red car, you're driving a little silly, probably because you're pissed. You met up with Erica in the car at the park. Now initially I believe you told us the gas station, do I have that right? And then you changed it to the park. So that's an inconsistency.
No, I said the house was by the gas station. You said what was by.
You said you went
Landmark.
and it was by a gas station, that's where you met her.
No. I said I met her at the park.
Okay.
At a
Well,
creek.
you met her,
I did say that.
You met her at the park in your mom's car. A red Ford Escape. She got in, you talked, and what you're telling me seems pretty consistent, that there was nothing physical between the two of you.
No.
But you met her in the car.
What's going on, man?
Asking you a question.
You
were out there
just tell
driving
me
kind
what's
of
going
crazy.
on,
Some
man.
people said you were driving kind of crazy. We got reports of it. You got the key, you got the car. Did you take the car or did your mom give you the car? I know you know what car I'm talking about.
I just want to know. So
Some people
Now,
reported,
listen,
you had all those
okay,
people
no,
out there
no,
that
no.
reported that car driving a bit erratic.
I know what you're saying. All I'm saying is this. We all been straight up with each other. You knew it was more to what you was asking me yesterday.
Didn't know
That
for
would
sure.
explain the FBI and all that, right?
They're not here today. So if it's that big a deal, you don't see them here today.
Come on, Kurt. Hey, we been.
You guys met in the car in the park.
We been cool, man, the whole time. If I did something wrong,
that's why they were
serious-
here. But do you see them here today? They're not here today.
Yeah, but y'all lied to me, man. You made it seem like they just come for no reason.
Well, here's the thing, Darrell.
And I'm like, what
Hey,
if it's
listen to
that?
me for a minute.
I apologize.
I can give you a clean slate here.
I apologize.
Because you have lied to us as well. Because you came out here in the red Ford Escape. Okay, that is what you came out here in. You had the key. Alright? So, what I want to do is try to give us all a chance to reset. You understand what I'm saying? Start over. Because you're not giving us an accurate story. You didn't ride out with Marcus in a tan car. You said your mom doesn't have a car. I just told you we've disproven that. All right? I don't know what kind of woman she is. I don't know what you all been through. But you were seen in the car driving kind of acting a fool. Okay?
All I want to know, like I said, y'all been cool with me. Am I charged with anything? That's all I want to know. I'll tell you anything you want to know.
Right now.
Listen.
You were driving a bit
So,
reckless.
listen.
Might be an OWI.
Listen. No, I don't drink.
You said you had a couple cold ones during the game.
Yeah, but I'm saying the hard alcohol is not my thing. I was not drunk. When you get the
Detective, can you explain what was occurring here during this clip?
The objection's noted. It's overruled. Go ahead. You may answer.
So in this clip here, my goal and intentions were with Mr. Brooks to start getting into the details of him driving the red Ford Escape through the parade route, and to begin confronting him with information about the Ford Escape key that had been found in his pocket. Obviously, to this point, Mr. Brooks had told us his mother didn't have a vehicle that she let him use. He didn't know if she had one at all. The vehicle was in his name.
Or is it his name?
I'm sorry, his mother's name, Mrs. Woods, Dawn Woods. It stated he didn't have a vehicle at all.
Objection, leading.
The previous objection, it's noted, it's overruled. The witness may continue.
He had made statements earlier in the interview he didn't have a vehicle at all, that he had ridden out in the Kia, which is not true. The investigation showed Mr. Brooks came out here in the red Ford Escape by himself, so he was in fact in possession of a vehicle. He was in fact driving a vehicle. In regards to the area, it should be known that Mr. Brooks's description of the park, Frame Park is the park where people in the parade, whoever they might have been, lined up. They were lining up at Frame Park. Frame Park is a park that has a body of water, as Mr. Brooks described, more specifically the Fox River running through it. So he was able to describe that park. There were people everywhere walking up and down the street, just as he said. Streets were closed off via barricades, via marked squad cars, via police tape. So he was able to describe that, and the way he described the area was exactly almost how the area looked with the parade. It was extremely crowded due to the people marching in the parade. It was in fact shown to be daylight when Mr. Brooks met with Miss Patterson and then departed from Miss Patterson. That is something we learned, and I was able to confirm that based on how he described it. And
the key found in the defendant's pocket, did that operate the red Ford Escape that was eventually located, that was registered to Dawn Woods?
Objection. That's been answered numerous times.
Overruled. The witness may answer.
There's never any depiction of a key being found in the defendant's pocket.
The objection is noted. It's overruled. The witness may answer.
Yes, it did. And, as we discussed the key more, you can even hear in there that Mr. Brooks acknowledges it should have been near his ID.
And was his ID also found in his pocket? Do you know?
Objection.
Yes, it was.
Please wait till I rule on the objection. Sustained as to the form of the question, I'll strike the last answer. Please rephrase.
Where was that, his ID found?
In his pocket.
Thank you. And the information you had, where was the key found?
Objection, leading.
Overruled.
Objections, hearsay.
Overruled. The witness may answer.
The key was found in his pocket.
Yeah, how do you know that?
Now, you also talked to Mr. Brooks about his phone. Where did he say his phone was?
According to Mr. Brooks, at this point, the phone should have been near him. I believe he said in the grass.
And what did you take that to mean? It should have been near him in the grass.
Objection. That was never stated.
Overruled. The witness may answer.
I would interpret it as right next to him, where he was arrested.
Okay, that's what just where he was arrested?
Yes.
Objection, leading.
Overruled. The answer may be given.
Yes.
After the defendant met with Erica Patterson, what did he describe his emotion as being?
Angry, frustrated over the fact that Miss Patterson brought him to the park and did not have the money to provide him that she indicated to him prior to that she would have.
Where did he say his flip-flops were?
Objection, answered.
Overruled. The witness may answer.
Well, when he indicated that he departed Stephanie's house, they were on his feet. However, during the course of his arrest, he indicates he doesn't know where they went. So somehow, apparently, they, I guess according to Mr. Brooks, disappeared.
Now, the clothes that the defendant's wearing in this video, specifically the red shirt, was that a shirt that was provided to him by law enforcement?
Objection, hearsay.
Overruled. The witness may answer.
No, ma'am, that's the same shirt he was wearing at the time of his arrest.
Did he indicate to you during this interview whether or not he had a coat?
Objection. So on the video.
Overruled. The witness may answer.
Mr. Brooks indicated that he did not.
And how long did he say he was on the porch with the homeowner whose house he was arrested at?
Objection. Relevancy.
Overruled. The witness may answer.
Mr. Brooks indicated that he did not.
And how long did he say he was on the porch with the homeowner whose house he was arrested at?
Objection. Relevancy.
Overruled. The witness may answer.
I believe it was like 20 to 30 minutes.
The weather that evening, was that an appropriate shirt to be wearing for 20 to 30 minutes outside?
Objection. Relevancy.
Overruled. The witness may answer.
No, it was not.
Right, so what had you so mad? Because you had your mom's car. Or I don't know if you use it. Who uses it? You got the key in the car. Is it hers? Is it yours that she lets you use? Let's clean that part up. Whose car is it?
It's my mom's car.
Okay. How often do you drive it?
Not very much.
It's the red Ford Escape?
It's all I want to know. Please. Just please. Whatever you can't tell me, I understand. I understand. All I want to know, just so I can have a peace of mind, just for my girls, man. What am I looking at?
Well, the fact you were kind of racing around up and down the street. That's the first part. Right? So, we're not quite there yet. I'm trying to figure out if I've got all my facts right first. So, this wasn't a three-way call. Let's back up to there for a second. How did you come to meet her in the park?
So y'all can't tell me nothing?
Well, you were driving.
And the video stopped at 1 hour, 41 minutes, and 30 seconds. Sir, is this the first time in this interview that Mr. Brooks acknowledged knowing about the red Ford Escape?
Objection. Leading, and that was not stated.
The objection's noted. It's overruled. The witness may answer.
I don't consent to being called that name for the record.
Overruled.
Yes, that is the first time.
No. Again, Mr. Brooks is asking about the charges. Did you recall seeing that on this clip as well as a clip contained within 1 hour, 19 minutes and 20 seconds and 1 hour, 38 minutes and 30 seconds?
Objection. Leading and compound questions.
Overruled. The witness may answer.
Yes, I recall that.
And again, what was the significance of that question in terms of timing of both clips?
Objection. Leading.
Overruled. The witness may answer.
I started talking to him about driving and just driving kind of fast. I had not noted to Mr. Brooks yet at that point that he had struck anybody. It seemed to me, based on Mr. Brooks's behavior, reasonable to believe that Mr. Brooks, it was clear to me he could remember something else happening, and I could sense what Mr. Brooks was attempting to do at that point was draw out of me more information. And again, as I stated in my earlier testimony, to gauge his truthfulness, I wanted to hear what he had to tell me about the incident before giving him too much specific detail. At this point, Mr. Brooks, for example, Miss Woods' vehicle, he indicated she did not own one. He had lied to me. There is the risk if I start giving him too much specific information, he's going to create a lie about what I gave him and so on. So Mr. Brooks kept insisting to know the charges before talking to me, but for the integrity of the investigation, that was something I couldn't and wouldn't provide him.
You know, you're charged with X, Y, Z. If you didn't do X, Y, Z, we gotta correct it. It's all fact gathering.
I just feel like y'all know more than what y'all say though, and that's what has me like why should I cooperate when there's no cooperation with me? Nothing I'm saying is gonna help me.
I mean, like, it doesn't make sense to you that we're trying to gather the facts.
Yeah.
Right.
I mean, I'm not saying it doesn't make sense, you know,
Okay.
what you guys are doing. I'm just saying I don't want to get railroaded by people not being honest. That's all I'm saying. If I don't know what I'm looking at, it's like, what the hell? Like, why should I just sit here and be like, oh, this is everything and blah 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 blah, and then people come back and be like, okay, now so now we're gonna charge you with this and this and this and this and this when y'all knew this from the door.
Well, we don't know that we're gonna charge you. We're that's again the fact
And
gathering.
it's like,
we're asking the questions about, you know what I mean? That's why we're.
What's going on here, sir?
Go ahead, ma'am.
So at this point, Mr. Brooks is still continuing to try to determine what exactly he's being charged with, and another part of this investigation is it was so broad. I didn't know exactly what some of those charges even were going to be. I had an idea, but I didn't know exactly. And in reality, what we wanted to know at that point is where he drove, have him tell us where he drove and why he did it.